Good morning.
Good morning. May it please the court. I'm Lewis Jenkins. I'm here for Ms. Bowen. I'd like to reserve 5 minutes, please. For
5 minutes, yes, sir.
Thought you were Mr. Agee, I'm sorry.
That is an understandable mistake, but I'm upright this morning, Your Honor, this is a healthcare liability case, and it's a question about what it takes for somebody to be able to testify under our version of the locality rule 2926-115. Our argument is straightforward, and it's either right or it's wrong, and that is this way that this normally gets done by what I've called in our brief the rote regurgitation of demographic data, the only way to do it, or is it the right way that it should have been done in this particular case? And we submit that it was not, and that Dr. Jim was an appropriate person to testify by virtue of the fact that here was the issue in this case. The issue was that Ms. Bowen presented at the hospital at Union City, and I was not involved in the trial court until the very end. But at the doctor in Union City was sued. We did not appeal against the grant of summary judgment from that doctor. The grant of summary judgment was against the grant of summary judgment that was appealed was the grant of summary judgment, the exclusion of Dr. Jim as to Dr. Bruno, who was here in Jackson in his practice, Jackson Radiology. And here's the question in this case: can the care that was demanded, that was necessary, should be the focus of whether or not the person is competent and able to testify under the locality rule. And Dr. Jim was very explicit about his knowledge. When somebody in Union City calls to the hospital in Jackson and says, I have a patient in need of urgent vascular care, the issue was that Ms. Bowen had a problem with her leg that required urgent vascular care. That was expressed to Dr. Bruno, at least the inference is, on the facts in the record at summary judgment stage, that it was expressed to Dr. Bruno. And Dr. Jim said, only one thing matters. Only one thing matters at that time. And this is that testimony that he gave mostly on page 49, which is at page 528 of the record. One thing matters. Do you have the ability, do you know that you have the ability to provide the care that's urgently necessary for this particular patient? And Dr. Jim said, I have worked in the situation where I'm on the receiving end of that, and I have worked in the situation where I'm on the referring end of that. And we say that positional experience is the relevant inquiry for determining whether Dr. Jim was a person, was able to testify under 2926-115. And that's really all that should matter in this case.
So, Mr. Jenkins, let me ask you something then. How does that square with the requirements of 29, I'll have to put my glasses on because I don't remember exactly, 2926-115?
So I square it in this way, Your Honor, which is that I go back to the beginning and I see that there's no legislatively provided definition of similarity. And so it's just the normal inquiry that we do as lawyers and judges every day, deciding what is relevant. And it's a basic question.
So you're not disputing then that the statute has got to be satisfied in order for Dr. Jim to be your expert witness?
As much as I would like to say that we could ignore this statute, which creates more problems than it does good, in my opinion, it's not.
I guess
I'm
you can
not
talk
here-
to your legislators then if
I'm
this is
not
what you
arguing
feel.
about the policy, Your Honor. I'm arguing about what it takes to fulfill the statute. Yes, ma'am, that's exactly what I'm saying. I agree that in order to be able to testify, he has to be eligible under both pieces of, so there's a rule of competence in A that's about whether or not he's got a license in Tennessee or one of the 7 adjoining states, and then there's the locality rule in B. And I agree that every person who's going to offer testimony about the standard of care must comply with both pieces of that statute. Yes, ma'am.
So what proof is in the record that your expert, Dr. Jim, satisfies the locality rule?
So I backed up to what's the purpose of the locality rule, and that's to establish similarity of communities. And so the way that normally happens, as Judge Parham pointed out in his last statement to me, why wasn't this simple task done? I can't answer that question, but there ought to be, and I think under the wording of the statute and under our rules of statutory interpretation, there's another way that can be satisfied, and the proof that he understood the requirements that were incumbent upon someone doing what Dr. Bruno did, which was accepting this patient who urgently needed vascular care at a larger hospital, is that he had been in that exact same position himself. He was the receiving physician for people who had been in that position, and he also testified to boot that he was the sending physician.
And so you use the term accepting the patient at a larger hospital. I bet that's the way you just said it. And what proof is in the record that Dr. Jim knew anything about the receiving hospital, in this case, Jackson-Madison County General Hospital? What proof is in the record of anything he knew about Jackson General or about the community as is referenced in Part A of that statute?
So I understand that, and I'll say that the proof that there's only one thing that was relevant in this case, only one thing, and that was the thing that he knew. The only question that matters in a case like this, where that you're referring a patient, you're accepting a patient who needs urgent vascular care, is do you have the resources to provide that care on an urgent basis? And that he knew that. He knew the one thing that was relevant, that Dr. Bruno should have known that and accepted the patient without knowing it and then couldn't provide the care. That's all that matters in this case. It's the only thing that's relevant. It's the only thing that makes any fact of consequence any more or less likely. How many beds the Jackson Hospital had is completely irrelevant. The only relevant inquiry is whether or not Jackson and Dr. Bruno knew that Jackson could provide the care that was urgently needed to this lady, or she was going to lose her leg, which is what happened. And that's all that matters. It is not an inquiry that I know. I do this. I know the easiest way to do this is to when you call your expert, to send them the demographic data so they can say, this is how many beds they have, this is the specialties they have. It doesn't matter what all specialties they have. It doesn't matter how many beds they had. It only matters whether or not Jackson had the resources to provide the care that was going to keep this lady from losing her leg. And they didn't.
How does he know that?
He knows that because Dr. Bruno was unable to articulate that, in fact, they had that.
Maybe Dr. Bruno was just a bad witness. Doesn't the expert have to have some knowledge of the medical community before he can contrast and say that there either has been a failure to exercise the appropriate care or not?
So
or we're just looking at a national standard of care, and we know where that goes,
Well,
or where it's gone so far.
so this, yes, sir, but this is not there's no slippery slope here, okay? Because the fact of the matter is, I get the locality rule. I understand that but it's not defined in the statute what similarity of community means. So judicially, we've had to try to parse out what that means. And one thing,
The Supreme Court has defined it pretty stringently, I suppose.
I don't think that's an exclusive definition, that the demographic data is an exclusive definition. I'm about to run out of time, Your Honor,
Well,
but.
And I don't know that it is either, but I know that it is the only way we've seen so far.
Can I answer?
Certainly, please.
So I think, Your Honor, that the answer to your question is that on the particular facts of this case, there's only one relevant characteristic that everybody needs to understand about the healthcare delivery system, and that is, this lady's in a rural hospital. She needs to get somewhere where this urgent care can be provided, or she's going to lose her leg. And nobody should accept her for care unless they can provide that care that she needs to keep her from losing her leg. That's really all, that's the only characteristic that matters. And Dr. Jim understood that. That's why that Brown versus Crown Equipment case was so important, because this is a case where his experience matters. His experience in being in that exact same position of accepting the patient for care and referring the patient for care was the thing that mattered. And I think that's enough on the facts of this case to let him testify.
Thank you.
All right, thank you, Mr. Jenkins.
Yes,
We'll
sir.
hear from
Thank
you
you.
on rebuttal. Good morning.
Good morning, Your Honors. May it please the court, my name is Samantha Bennett. I'm an attorney with Lewis Thomason in Memphis, and I represent Dr. Gregory Bruno and Jackson Radiology Associates in this matter. Before I get into the argument, because Mr. Lewis was so adamant in what's relevant here, I wanted to address that at the outset. And what the argument was the only thing that mattered was whether Jackson General Hospital had the resources to treat the patient. I can tell you right now the answer to that question is no. So even for the question that plaintiff's counsel says is relevant, which we disagree that satisfies the locality rule, but even if we take that, Dr. Jim can't satisfy that. Dr. Jim clearly testified that he does not know what resources, what medical resources, what treatment, what specialties are available at Jackson Madison County General Hospital. So there's no way he can provide that testimony.
What did Dr. Jim in the record testify that he did know about the hospital or the medical community in Jackson?
Two things. With respect to the Jackson community, he knew that it was, in his words, approximately 1.5 hours northeast of Memphis. That was what he knows about Jackson. With respect to Jackson Madison County General Hospital, he testified that he only knew that is where the plaintiff received some of her care. That is it. That is all that is in the record with respect to Dr. Jim's knowledge of Jackson, the Jackson community, or Jackson Madison County General Hospital.
Thank you.
Now to address the heart of this, the locality rule. The plaintiff in this case is challenging both the award of summary judgment and the trial court's exclusion of Dr. Jim, which was based on, the summary judgment was based on the exclusion of Dr. Jim's standard of care testimony. And these two issues are governed by different standards of review. And this court will review the trial court's exclusion of Dr. Jim's standard of care testimony under an abuse of discretion standard, and will review the trial court's grant of summary judgment de novo. The trial court in this case did not abuse its discretion when it held that Dr. Jim did not satisfy the locality rule, and in the absence of any standard of care testimony against Dr. Bruno, the trial court correctly granted summary judgment in favor of Dr. Bruno and his employer, Jackson Radiology Associates. And this court should therefore affirm the trial court's rulings. Turning first to the trial court's exclusion of Dr. Jim's standard of care testimony, the plaintiff in this case alleges that Dr. Bruno deviated from the standard of care and the treatment provided to the plaintiff, Ms. Bowen, and caused harm that would not otherwise have occurred. The only allegation against Jackson Radiology is vicarious liability for the actions of Dr. Bruno. Plaintiff identified one standard of care expert against Dr. Bruno, and that was Dr. Jim. In the year preceding the events at issue in this case, Dr. Jim was a vascular surgeon practicing in St. Louis. Plaintiff's defense counsel deposed Dr. Jim, and based on Dr. Jim's testimony, the defendants brought a motion to exclude him as a standard of care expert pursuant to Tennessee Rules of Evidence 702 and 703 because he failed to satisfy the locality rule, making his testimony untrustworthy and such that it would not substantially assist the trier of fact. Tennessee's locality rule is embodied in TCA 2926-115A1, and it requires that an expert being offered as a standard of care expert to establish the recognized standard of acceptable professional practice in the community in which the defendant practices or in a similar community. In the seminal case in Tennessee on the locality rule is Shipley versus Williams, which at this point is a longstanding precedent in Tennessee. In Shipley, the court, reaffirming prior precedent, said that a medical expert must demonstrate a modicum of familiarity with the medical community in which the defendant practices or a similar community. The Shipley court went on to offer guidance on how an expert can satisfy the locality rule, and the court discussed three avenues for doing that. The first, which has been discussed this morning so far, is by having the expert review data, pertinent statistical information regarding the community, hospital size, community size, number of specialties, number of medical facilities, those types of things. Second, the expert can discuss with other medical providers in the pertinent community regarding the applicable standard of care. Or third, the expert can visit the community hospital where the defendant practices. The locality rule allows for the satisfaction in one of two ways. The expert can either testify that he or she is familiar with the community in which the defendant practices, or can testify regarding the characteristics of another community and then testify that that community is similar to Jackson. Either way, neither one of these avenues can be fulfilled without the expert having information regarding the Jackson, Tennessee community. If we look at Dr. Jim's testimony, it is very clear on what Dr. Jim did not know. Dr. Jim did not review or have any knowledge of the pertinent statistical data related to the Jackson, Tennessee community. He admitted that for the relevant time frame, which was the 2018 time frame, he didn't know the population of Jackson. He didn't know what medical facilities were in Jackson other than Jackson General. He didn't know what medical services were available in Jackson or at Jackson Madison County General Hospital. He didn't know what specialized practices were available in the community or at Jackson Madison County General Hospital. Again, the only thing he knew was that Jackson is a suburban or rural city in Tennessee that's about an hour and a half northeast of Memphis. He testified that all he knows about Jackson General is, again, that's where the plaintiff received some of her care. When asked about the size of Jackson General in terms of the number of beds, Dr. Jim's testimony was, I don't know. He went on to guess that it was a couple of hundred beds, maybe, or even less than that. In fact, Jackson Madison County General Hospital has 3 times that number of beds. Over and over again, Dr. Jim's answer when questioned about what he knew was, I don't know, I don't know. So clearly, Dr. Jim cannot satisfy the locality rule by acquainting himself with pertinent information. He also could not satisfy the locality rule with testimony that he discussed with other medical providers in the community the applicable standard of care. Dr. Jim readily admitted he's never practiced in Jackson, he's never worked with any physicians in Jackson, he's never discussed the standard of care in Jackson with any other Jackson physicians, he's never made any effort at all to inquire about the standard of care in Jackson in 2018 in order to offer his opinions against Dr. Bruno. Turning to the third way that Shipley provides guidance for satisfying the locality rule, Dr. Jim could also not satisfy the locality rule with testimony that he'd been to the community in which Dr. Bruno practices, which is to be the Jackson community. Dr. Jim testified that he does not recall ever having been to Jackson, which also would mean he'd never been to Jackson General. In sum, Dr. Jim simply fails to satisfy the minimum requirements of familiarity required to satisfy the locality rule with respect to the Jackson community. While this modicum of familiarity requirement is an admittedly low threshold, it requires some knowledge, some useful knowledge. And Dr. Jim's knowledge of where Jackson is located geographically in relationship to Memphis simply does not satisfy the locality rule. Shifting gears under 115A1, and the locality rule, as Shipley discussed, the locality rule can also be satisfied by an expert testifying that he or she is familiar with a different community and then testifying that that community is similar to Jackson. We know just from this discussion, Dr. Jim can't satisfy the locality rule in that way because without knowing anything about Jackson, it is impossible for Dr. Jim to make any comparisons between Jackson and any other community. The plaintiff contends that Dr. Jim's relevant experience at I think that in the brief they say a particular juncture within the overall healthcare delivery system satisfies the locality rule. This is simply not true. Regardless of the words that the plaintiff uses to couch her argument, the test is whether or not Dr. Jim has demonstrated the required minimum degree of familiarity with Jackson, Tennessee, or a similar community. This issue about Dr. Jim's experience that the plaintiff points to, it really more appropriately speaks to his competency to serve as an expert under 115B, and whether Dr. Jim's experience as a vascular surgeon is a specialty that would make his testimony relevant. It does not establish in any way any degree of familiarity with the Jackson, Tennessee community. Again, the question is not Dr. Jim's experience, it's his knowledge, and he simply has none. In support of her argument and her brief, the plaintiff makes a number of statements implying that there are similarities between Jackson and St. Louis and Jackson General and hospitals in St. Louis. These testimonies, those statements in the plaintiff's brief are not supported by Dr. Jim's testimony. Dr. Jim's testimony is absolutely void of any facts that illustrate similarities between Jackson and St. Louis or any hospital in St. Louis and Jackson Madison County General Hospital, which again is not surprising because Dr. Jim knows nothing about Jackson. In the trial court and on appeal, the plaintiff tried to shift focus away from the locality rules requirement of familiarity of community to hospital familiarity. And the plaintiff focused a lot on questions that were posed to Dr. Jim during cross-examination by plaintiff's counsel in an effort to rehabilitate Dr. Jim's testimony. In that testimony, Dr. Jim makes statements about other communities, smaller hospitals, smaller community hospitals. These are bare assertions that are made by Dr. Jim in this cross-examination testimony. There's no description of these other communities that Dr. Jim talked about. And again, without knowing what these other communities are and their characteristics and not knowing anything about Jackson, you can't say that they're similar. Same thing applies to the hospitals. Without knowing anything about Jackson General and not knowing anything about these smaller hospitals that Dr. Jim is referring to, there's no way that any comparison can be drawn. Additionally, this idea that you can focus on hospital familiarity versus community familiarity is not contemplated by 115A1 or Shipley. Black's Law Dictionary defines community as a larger body, a neighborhood, vicinity, locality. And throughout Shipley, the Tennessee Supreme Court talks about medical community, which read in the context of the larger opinion would include general community demographics as well as specifics to the medical community, and then to a facility or provider, specifically depending upon the nature of the care at issue. It's our position that the locality rule cannot be satisfied simply by comparing hospitals without regard to the larger community. But even if that could be used to satisfy the locality rule, Dr. Jim's testimony still does not get them there. Remember, Dr. Jim testified that he knew nothing about Jackson-Madison County General Hospital other than that's where the plaintiff received a portion of her care. Not describing these smaller hospitals in this reference, it's impossible to know or draw any comparison between these smaller hospitals and Jackson General. However, when Dr. Jim testified about the size of Jackson General, he guessed that it had a couple of hundred beds. If Dr. Jim was in fact using that erroneous figure to draw comparisons between Jackson-Madison County General Hospital and these smaller hospitals that he doesn't describe, Dr. Jim's testimony that these hospitals are similar is simply incorrect. Again, Jackson-Madison County General has over 600 beds. In Dr. Jim's testimony, he testified that a hospital with 600 or 700 beds would be considered a large hospital, so he can't satisfy it that way. If we look at the abuse of discretion standard in this case, the trial court appropriately applied the governing legal principles and to the facts that were in the record and reached a reasonable conclusion. The trial court did not abuse its discretion when it excluded Dr. Jim's standard of care testimony under Rules 702 and 703. Likewise, the trial court did not abuse its discretion in precluding Dr. Jim from testifying regarding a national standard of care because under Shipley, a national standard of care can only be discussed once the expert has demonstrated and has satisfied the locality rule. Having properly exercised its discretion in excluding Dr. Jim as an expert on standard of care against Dr. Bruno, the summary judgment was appropriate. The plaintiff was left without any expert to testify as to the standard of care applicable to Dr. Bruno or any deviation therefrom, and therefore summary judgment was properly granted. We ask that this court affirm the trial court's exclusion of Dr. Jim as an expert on standard of care against Dr. Bruno and affirm the trial court's grant of summary judgment.
Thank you, Ms. Bennett. Mr. Jenkins, your rebuttal.
Yes, sir. May it please the court. It's ironic that we're here focused on what Dr. Bruno says Dr. Jim doesn't know about the Jackson community when the real problem is that Dr. Bruno didn't know. The only question that matters in this case is whether or not Dr. Bruno knew that the care was available, that the resources were available to provide the care for this woman who urgently needed it, and it wasn't. That question really narrows the focus of similarity. So I grew up in a little tiny town called Rogersville in northeastern Tennessee. This is not a situation where someone walks into a primary care physician's office in Rogersville and needs help with something that person has no resources to address, none. The locality rule protects that person because of the contextual analysis of them not having the resources available. That analysis has zero applicability where the question is, did Dr. Bruno know that he had available at the place where he was the resources to address this lady's urgent problem at the time that he accepted the patient for care? It's not a situation where he had this patient involuntarily thrust in his face and didn't have the resources to provide the care. That's what the locality rule exists to address. This is a case where he said yes to somebody he knew needed urgent care, and he either did not know whether or not he had the resources available to provide that care when he accepted the patient to be cared for, or he did know that those resources weren't available and he just did it anyway. I don't know which one of those answers is true, but either one of them, I think, is required to be credited to the plaintiff at the summary judgment stage. Because of the specific circumstances of this case, and I'm not hiding the ball about anything, I have never said that Dr. Jim looked at any demographic data. I wish that he had. It would have been totally meaningless. It wouldn't have had any impact on his criticism. It wouldn't have had any impact on the failure of Dr. Bruno to know whether or not he had the resources available to care for this patient who was about to get her leg cut off. But I wish he had, because we wouldn't be here and we'd be up in Union City arguing about the real question in front of a jury. But since this is where we are, the question is how to analyze the concept of similarity on the particular facts of this case. And in the particular facts of this case, where a doctor says, yes, send that patient here, I can take care of that patient, similarity gets very narrow. It doesn't matter how many beds are in the hospital. It only matters whether that person who says yes knows that the resources are available to care for this patient who has an urgent need. And Dr. Jim demonstrated that he had that kind of familiarity with that situation where he was saying yes, because he said, I've done it before. I've said yes before to the care of these patients who need this urgent care. It's a little bit different than a normal case, and it really brings home that the concept of similarity has to be adjusted to the facts of each particular case. And since there's no legislative definition, adjusting it to the facts of each case is exactly what this court should do. And in this case, Dr. Jim has demonstrated familiarity with the only relevant characteristic that mattered, whether or not the person who said yes knew that the care could be provided to this person who needed it so urgently. Thank you.
All right. Thank you, Mr. Jenkins and Ms. Bennett, for your arguments. We'll take this matter under advisement. That concludes the morning docket.
All rise.